So you might remember a couple years ago, John Steele and Paul Hansmeier of Prenda Law were sentenced to 6.5 and 14 years in federal prison for running a copyright infringement BitTorrent file sharing based honeypot scheme to catch and extract settlements from defendants or BitTorrent users who potentially infringed on Prenda Law's clients' copyrighted works. This is an ongoing problem with different plaintiffs. For instance, Strike 3 Holdings currently prosecutes these exact same kinds of things, but Strike 3 has so far, as best as we know, stopped short of creating their own copyrights for the purposes of catching infringers, uploading them to BitTorrent file sharing swarms or streams, or however you want to refer to that, making these copyrights available via piracy so that they can then log activity on swarms of BitTorrent users and then sue them. Well, Paul Hansmeier and John Steele, through Prenda Law, they did cross the line, and they were eventually charged with mail fraud and wire fraud. Among other things that they did was setting up a honeypot to catch infringers, but through providing the copyrighted works to piracy websites like the Pirate Bay to get infringers to sue. Sometimes they would file a lawsuit against thousands of defendants and then get one of the defendants to snitch on the others through an affidavit, through testimony that they were part of a large conspiracy of thousands of people, when it turned out that these people were entirely unrelated, were not part of the same quote-unquote transaction or occurrence, and simply may have been downloading the same file. And that was all considered to be mail fraud and wire fraud, and Paul Hansmeier was sentenced to federal prison at Sandstone in Minnesota. So this is where Paul Hansmeier is currently housed. He's literally in this building right now as we speak. Well, there has been an update, because Paul Hansmeier has been trying to restart his copyright infringement honeypotting extortion scheme from prison. And it has now reached the point where a court has had to intervene. Here is a memorandum opinion in order granting a motion to dismiss Paul Hansmeier's lawsuit and granting the motion for filing restrictions. Paul Hansmeier is now some kind of vexatious litigant who is not allowed to file more things with the court, except under the circumstances the judge will outline here. Let's see what's going on. Paul Hansmeier is registered under prisoner number 20953-041 at the Federal Correction Institution, P.O. Box 1000, Sandstone, Minnesota 55072. Paul R. Hansmeier, proceeding pro se on his own without an attorney, has filed at least 16 actions in this district alone, challenging the constitutionality of the federal mail fraud, wire fraud, and extortion statutes against David McLaughlin and W. Anders Folk, the federal defendants. The court stayed the proceedings of the other active cases pending resolution of the motion to dismiss presently before the court in this case. Because Hansmeier has litigated this exact issue not once, but at least twice before, and because all other elements of issue preclusion are met, Hansmeier's claims are barred by res judicata, and the court will grant federal defendants motion to dismiss. The court will also dismiss Hansmeier's complaint against the defendant, Portland Corporate Center, for failure to effectuate service under Rule 4. Furthermore, because Hansmeier has shown he has no reservations in filing frivolous, meritless, duplicative, and arguably harassing lawsuits against the federal defendants, the court will impose appropriately tailored filing restrictions against him. Oh, how he fell so far. Background. Hansmeier is currently serving a 168-month prison sentence at FCI Sandstone. In 2018, Hansmeier, then a licensed attorney, pled guilty to conspiracy to commit mail fraud and wire fraud in violation of the law and conspiracy to commit money laundering. Following the conviction, the Minnesota Supreme Court disbarred him due to his multi-year history of misconduct. Since his incarceration, Hansmeier has been involved in copious amounts of litigation on the alleged unconstitutionality of the challenged statutes as applied to him. As applied is a legal term for a constitutional challenge. There is a on its face or facially deficient statute and an as applied challenge to a constitutional issue or a statute. His lawsuits, all of which seek declaratory and injunctive relief, allege that the statutes are unconstitutional because they either prevent him from pursuing copyright enforcement or prevent him from assisting unidentified individuals pursuing Americans with Disabilities Act enforcement claims. So he was not only a copyright troll, he was an ADA troll as well. In May 2020, Hansmeier filed a lawsuit in the District Court for the District of Columbia against U.S. Attorney General William Barr, asserting the unconstitutionality of the challenge statutes as they applied to copyright enforcement actions he sought to undertake. U.S. District Judge James Boasberg screened the case pursuant to the in forma pauperis statute and determined that the Attorney General has absolute discretion in deciding whether to investigate claims for possible criminal and civil prosecution, and such decisions are not subject to judicial review, so separation of powers issues. The court dismissed the complaint for failure to state a claim. Hansmeier did not appeal this decision. Hansmeier then filed a complaint against Attorney General Barr in the Western District of Wisconsin that was nearly identical to the previously dismissed case. The case was closed because he failed to pay the initial filing fee. Hansmeier was also busy in this district, Minnesota, filing a lawsuit before Judge Brazel in June 2020 against U.S. Attorney Erica McDonald for declaratory and injunctive relief on the constitutionality of the challenged statutes as they apply to his proposed ADA enforcement strategy. Hansmeier was not finished, though, as he proceeded to file at least 16 additional cases challenging the constitutionality of the challenged statutes as applied to him and his enforcement strategies, including this case. As relevant to this motion in Hansmeier I, Hansmeier filed a document titled Suggestion of Mootness, and upon that motion the court found that the particular case no longer presented a live controversy, dismissing it without prejudice. In Hansmeier II, Hansmeier filed a notice of voluntary dismissal. The court stayed the remaining actions until the motion to dismiss is resolved in this present case. The court will review the standards for a motion to dismiss. A claim must have facial plausibility. The plaintiff must plead factual content that allows a court to draw a reasonable inference that the defendant is liable for the misconduct alleged. So this is the standard for a complaint to survive a motion to dismiss. You don't have to prove your case at the complaint stage. You just have to tell the court and the defendant what is going on, factually what's going on, connecting that to a law or claim for relief, and connecting that to proper jurisdiction. And if you make a short, plain statement of the facts and a claim for relief and a statement about jurisdiction, that should be enough to survive a motion to dismiss. But if the claim to relief is invalid, if jurisdiction is invalid, if your short, plain statement of the facts doesn't really state the facts necessary to connect things, then the complaint hasn't risen to the level that it will survive a motion to dismiss, and it will be dismissed. Analysis: res judicata. A res judicata defense is appropriate to raise on a motion to dismiss if the identity of the actions relevant to the argument are apparent from the face of the complaint. The relevant cases to be considered are the following: the District of Columbia case before Judge Boasberg, the June 2020 lawsuit before Judge Brazel, and Hansmeier I and Hansmeier II here in Minnesota. As each of the four relevant lawsuits include nearly identical parties and issues, the identity of these actions is apparent on the face of the complaint, and the defense of res judicata can be considered on the motion to dismiss. What is res judicata? Res judicata incorporates two concepts: issue preclusion and claim preclusion. Issue preclusion forecloses relitigating an issue that has already been litigated and decided. This is similar to the double jeopardy concept in criminal law, where you can't be charged with the same crime twice, or you can't be convicted for the same crime twice. If you've been acquitted of murder, you can't be charged with murder under the same facts. A party is precluded from litigating such a matter in a subsequent case, whether or not the issue arises on the same or a different claim. So just filing a different piece of paper, making it a different case, doesn't mean that you can sue twice. Issue preclusion applies if the following five elements are met. 1, the party sought to be precluded was a party or in privity with a party in the original lawsuit. 2, the issue sought to be precluded must be the same as the issue involved in the original lawsuit. 3, the issue must have been actually litigated. 4, the issue must have been determined by a final and valid judgment. And 5, determination of the issue in the prior action must have been essential to the judgment. According to the federal defendants, there are 2 separate lawsuits that meet the elements of issue preclusion and warrant dismissal of Hansmeier's claims in this action under the doctrine of res judicata. Judge Boasberg's July 2020 order. Hansmeier only seriously contests whether the second element of issue preclusion is met when analyzing his lawsuit before Judge Boasberg. However, the court will consider each element in turn. The first element, whether the parties were the same or in privity, is met here because the federal defendants are in privity with Attorney General Barr. Privity is a legal term for having a close enough relationship with something. If you are a party to a contract, then you are in privity with that contract. If you are a representative of a party to that contract, then you also have privity with that contract. But if you're some other person who didn't sign the contract and isn't part of the corporation or the entity or something, you're not in privity with that. And the privity analysis is really an analysis of the relationships between the parties or the people and the companies. As to the second element, Hansmeier contends that the case before Judge Boasberg did not involve the same issue because the dismissal in that case centered on Hansmeier's use of the word pursue in his complaint. Hansmeier claims that Judge Boasberg focused on his request to enjoin, or get an injunction, against the U.S. Attorney General from pursuing Hansmeier under the challenged statutes for his actions and concluded that the complaint must be dismissed for lack of subject matter jurisdiction. Hansmeier had preemptively sued and tried to get permission from the court that his copyright honeypotting scheme is legal and he wouldn't be charged with mail fraud or wire fraud or extortion or some other statute for pursuing his copyright honeypotting scheme from prison. And that's really not how the law works. I get that it would be nice if we could get a judgment or get a ruling that what we're doing is legal. I want to go ride my one wheel around Allentown, but the law doesn't say one way or the other whether it's legal to ride a one wheel. That's not really how that works. In the US, you have to first do the thing, then get charged, and then defend yourself in court. It's not necessarily easy, but the Constitution requires a live case or controversy, and a request for permission to do something is not ripe for litigation or for adjudication. And then something that happened in the past that can no longer be adjudicated is moot. So that's the ripeness and mootness doctrine as it relates to a case or controversy. So Hansmeier doesn't have a live case or controversy until he actually does the thing and gets charged, and then he can defend himself. Since the complaint in this case did not use the word pursue, Hansmeier argues the second element of issue preclusion is not met. Hansmeier's assertions are unpersuasive for 3 reasons. First, Judge Boasberg stated clearly that the matter would be dismissed because Hansmeier stated no plausible claim to relief, as the Attorney General has absolute discretion or absolute power to investigate and prosecute. There is no mention of jurisdiction in Judge Boasberg's order. Second, Judge Boasberg's order never states that the decision turned solely on the use of the word pursue, so omission of that word in the complaint in this case is inconsequential. Lastly, the court sees little difference between the relief requested by Hansmeier in his case before Judge Boasberg to enjoin the U.S. Attorney General from pursuing claims against him from the relief he requests here to enjoin the other federal defendants from enforcing the challenged statutes against him. By cabining the doctrine of res judicata to apply only when a litigant uses identical wording would severely limit the effect of the doctrine, significantly weakening it. Thus, the issue sought to be precluded here is the same issue involved in the case before Judge Boasberg, and the second element of issue preclusion is met. The third element is met because the issue was the basis for Judge Boasberg dismissing Hansmeier's claim. Hansmeier asked for declaratory relief related to the enforcement of the challenged statutes, mail fraud and wire fraud and extortion, against him, and Judge Boasberg held that he failed to state any plausible claim entitling him to that relief. The fourth element is likewise met because a final judgment for purposes of issue preclusion includes matters resolved by preliminary rulings or determinations of liability that have not yet been completed by an award of damages or other relief. A judgment must be sufficiently firm to be accorded conclusive effect. Judge Boasberg's dismissal was sufficiently firm and therefore meets this requirement. The fifth element is met because Hansmeier's failure to state a plausible claim was the sole grounds for dismissal. Thus, Hansmeier's lawsuit before Judge Boasberg meets all of the elements of issue preclusion, and his relitigation of the same issues in the present matter is foreclosed. Based on this, the court will grant the federal defendant's motion to dismiss the case because his claims are barred by the doctrine of res judicata. Hansmeier's lawsuits in Minnesota. The elements of issue preclusion are met based solely on Hansmeier's lawsuit before Judge Boasberg, and thus res judicata warrants dismissal of his complaint based on that lawsuit alone. However, the cases Hansmeier has brought in the District of Minnesota, the case before Judge Brazel, and Hansmeier I and II, provide a separate ground to dismiss under issue preclusion. As to these three cases, Hansmeier only raises a serious challenge to the fourth element, that the issue was determined by a final and valid judgment. The court will still consider each element. The first element is met because the parties are nearly identical. The second is met because the issue is nearly identical. We can probably skip some of this. Hansmeier's lawsuits focus on enjoining the federal defendants from potentially prosecuting him in the future under the challenge statutes for actions that he would like to undertake. The fact that he raises this issue in relation to either copyright or ADA enforcement is irrelevant. The third element is met for similar reasons. The core issues are identical and were actually litigated. Hansmeier argues that the fourth element of issue preclusion is not met because his voluntary dismissals in the prior actions cannot constitute final and valid judgments. Rule 41, which states that voluntary dismissal results in a dismissal without prejudice unless the plaintiff previously dismissed any federal action based on or including the same claim. So you can voluntarily dismiss once, but if you do it again, it's going to count as a with prejudice dismissal, or an extinguishment or extinguishing of the claims. It acts as an adjudication of the claims. The notice of dismissal acts as an adjudication on the merits. He claims that there was no adjudication on the merits and thus no final and valid judgment because the multiple voluntary dismissals were in lawsuits that did not involve the same claims. But there is no dispute that Hansmeier voluntarily dismissed his ADA enforcement lawsuit against federal defendants before Judge Brazel. Thus, if either Hansmeier 1 or 2 constitutes an action based on the same claim as the claim at issue in the Judge Brazel case, Hansmeier's second voluntary dismissal would constitute an adjudication on the merits and meet the requirements of the fourth element of issue preclusion. The court is unpersuaded by the federal defendant's argument that the suggestion of mootness in Hansmeier 1 constitutes a voluntary dismissal. The court did not treat it as a voluntary dismissal when the court dismissed the case, denying the motions in the case as moot and dismissing without prejudice. As such, the resolution in Hansmeier 1 was not a voluntary dismissal and cannot constitute an adjudication on the merits. Hansmeier 2, however, is different. Hansmeier filed a notice of voluntary dismissal in Hansmeier 2, not a suggestion of mootness which the court granted. Hansmeier argues that this voluntary dismissal does not operate as an adjudication because Hansmeier 2 did not involve the same claims. Hansmeier claims that for Rule 41 to apply, he would have had to bring and then voluntarily dismiss 2 lawsuits challenging the constitutionality of the statutes as applied to ADA enforcement against Portland. The court does not read Rule 41 so narrowly. The issue is still the same. Hansmeier asks the court to enjoin the enforcement of the challenge statutes against him based on certain activities he would like to undertake. Though there is a slight variation in the claims asserted, the ultimate issue for resolution remains the same. Because Hansmeier had voluntarily dismissed his case before Judge Brazel and then proceeded to voluntarily dismiss Hansmeier 2, this second voluntary dismissal constituted an adjudication of the merits. Therefore, there was a final and valid judgment on the claim, and the fourth element of issue preclusion is met. In sum, the cases brought in the District of Minnesota meet the elements of issue preclusion and provide a second ground which Hansmeier's instant claims are precluded. As such, Hansmeier's claims are barred by the res judicata doctrine, and his suit must be dismissed. Then the court talks about the failure to properly serve the Portland Corporate Center. I'm assuming the Portland Corporate Center is a victim of his ADA enforcement scheme. Hansmeier has failed to properly serve defendant Portland pursuant to Rule 4. Rule 4M provides that if a plaintiff fails to serve a defendant within 90 days after the complaint is filed, the court must dismiss the action without prejudice against that defendant or order service be made within a specific time. The complaint was filed May 2021. In September of 2021, Hansmeier filed a motion to extend time for service, requesting the court grant him an extension until March 1st, 2022. Hansmeier claims that he has made attempts to serve them, though he has presented no evidence that supports this assertion. Hansmeier goes on to state that his ability to serve Portland has been significantly impaired by the fact that the Bureau of Prisons has placed him in administrative detention, which gives him access only to food, water, a legal pad, and a pen. Oh boo-hoo, I feel so bad for him. It is unclear why, as of March 1st, 2022, Hansmeier's requested date to serve Portland, no such service has been made. Hansmeier's most recent court filings indicate that he is no longer in administrative detention, and the court points out a typed document filed by Hansmeier in January of 2022. And Hansmeier admits himself that he was released from administrative detention by November of 2021. Hansmeier provides no justification for why he has failed to serve Portland in the last 5 months when it appears he has had every ability to do so. Meanwhile, there is a motion for filing restrictions. There is no constitutional right of access to the courts to prosecute an action that is frivolous or malicious, and indeed, defendants have a right to be free from harassing, abusive, and meritless litigation. Who would have thought? Federal courts have inherent authority to impose sanctions to regulate their dockets, promote judicial efficiency, and deter frivolous filings. The court may, in its discretion, place reasonable restrictions on any litigant who files non-meritorious actions for obviously malicious purposes, who generally abuses judicial process. Hansmeier has filed at least 16 duplicative cases challenging the constitutionality of the statutes as applied to him and his enforcement strategies. Hansmeier asserts these lawsuits are not duplicative because the complaints are narrowly tailored to the specific facts identified in each case. Each case, though, ultimately centers on a determination of the constitutionality of the challenged statutes. Let me see what footnote 5 here says. Footnote 5 notes that Hansmeier argues that the court cannot consider any additional motion outside of the motion to dismiss because it has stayed all proceedings until the motion to dismiss is resolved. Hansmeier points to the language in the court's August 2021 order, where the court stated it will not entertain any other motion or request while the motion to dismiss is pending. The court, though, noted its concern with the sprawling litigation initiated by Hansmeier and stayed all other proceedings to avoid further strain on the court's and parties' resources. The court continues to be concerned with the drain Hansmeier's litigation has had on the resources of all those involved and sees no reason to defer ruling on the motion for filing restrictions. This is particularly true where both sides have had the opportunity to brief the issue for the court. As such, the court will rule on the motion. This issue has previously been decided as detailed above and is barred by res judicata. Hansmeier's insistence on filing numerous lawsuits on identical issues in the hopes of reaching a different outcome can only be described as frivolous and duplicative, if not arguably harassing and abusive. Hansmeier's litigiousness has drained resources not only from this district, but the District of Columbia and the Western District of Wisconsin. His actions have also required the federal defendants to dedicate time and resources in defending against meritless lawsuits again and again. To regulate this district's docket, promote judicial efficiency, and deter frivolous filings by Hansmeier, the court will place appropriately tailored filing restrictions on him. In the event that Hansmeier initiates in the U.S. District Court for the District of Minnesota, without express prior written permission from the Chief Judge of the District of Minnesota, any copyright infringement action or private enforcement action under the ADA against the U.S. Attorney General, former acting U.S. Attorney Folk, any future U.S. Attorney for the District of Minnesota, Assistant U.S. Attorney McLaughlin, former U.S. Attorney Lugar, or the U.S. Attorney's Office for the District of Minnesota, the clerk is directed to immediately close the case and the court will dismiss it without prejudice. Furthermore, any action removed to the District of Minnesota that meets the description above is also subject to immediate closure by the clerk and dismissal without prejudice by the court. Removal is if there's a state court action that then gets transferred to the federal court. We call that removal. Based on the foregoing, federal defendant's motion to dismiss is granted. Hansmeier's complaint is dismissed with prejudice. Hansmeier's complaint is dismissed without prejudice as to the Portland Corporate Center, and the filing restrictions are granted as described above. The motion to consolidate cases is denied as moot. The court lifts the stay. Each of Hansmeier's other matters are dismissed with prejudice. All pending motions are denied as moot, and that is Chief Judge John R. Thunheim of the United States District Court for the District of Minnesota, March 11th. Oh, how they fall so far. I got my start as a copyright attorney defending people from, among other things, Prenda Law's, John Steele's, Paul Hansmeier's, and Paul Duffy's frivolous, I think frivolous, copyright lawsuits. Many of my clients paid settlements to Hansmeier and Steele and Duffy and Prenda Law because they were afraid of litigation. Everyone has their own reason for it. Sometimes they think they might be liable. Sometimes they don't have the ability to defend themselves. They don't have the resources. They can't handle the stress of it. Many people cannot handle being sued and go on with their lives without it having a severe impact. Sometimes that impact is so great that it's easier to pay thousands of dollars than it is to face that stress for potentially years. Even if later on you'll be vindicated and win, it's still an empty victory and a loss. And until there's some kind of severe sanction for people who file these things, it won't deter the filing of these kinds of frivolous and frankly illegal lawsuits. Paul Hansmeier and John Steele's lawsuits were illegal as they were found guilty or pled guilty to mail fraud, wire fraud, and extortion. So literally a copyright extortion racket. So I couldn't be happier to see that they're serving federal prison sentences. I couldn't be happier that Paul Hansmeier is wasting away in a federal penitentiary, handwriting and now I guess typing his frivolous lawsuits, and now he can't file them anymore without them being dismissed. He can't file them without the permission of the chief judge. So now everything he files has to go through the chief judge first before it can be filed with the clerk of courts, and that means he won't really be filing much at all. He may try, and maybe we'll see something about that, but he still has years left. I think he still has 10 years left on his prison sentence, maybe a little bit less with good behavior and stuff. Who knows? But he's been disbarred. He's not going to be practicing law anytime soon. I don't think he's going to be practicing law at all for the rest of his life, frankly. And he's going to have to find a way to live without harassing people for shakedown money, extortion money in a copyright or Americans with Disabilities Act honeypotting scheme. It's unbelievable, but the text is right in front of you. Let me know what you think in the comments below. And that's today's video. Special thanks to my top supporters in March: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, The Blood-Soaked Survivors, and Wyatt Calandro. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. Oh, 1915A is the In for a Pauperist statute. The elements of issue preclusion are met based solely on Hansmeier's lawsuit before Judge Boasberg, and thus res judicata. Race judicata? It's F1 weekend, guys. Sorry. Car racing is on my mind, Toto. We went auto racing.